Good morning, everybody. Thanks for the invitation to come in today. I'm honored to be here. Jim Haggerty. I am the Magistrate District Judge in Kingston and Edwardsville, doing that after 20 years being mayor of Kingston. I'm up for re-election this year after serving a six-year term, and I'm seeking the honor of a re-election from the folks I represent in Kingston and Edwardsville. And I'm running for re-election because I have a long history of serving my community, service as mayor, but service for charitable organizations like the Hoyt Library, like Dinners for Kids. I want to continue to serve my community in this regard. Also, I'm running because I think I'm the best qualified candidate to be the magistrate in Kingston and Edwardsville. I've been an attorney for 33 years. I'm a graduate of Georgetown University Law School. I was a cum laude graduate there. I have a bachelor's degree from MIT. I've worked throughout the country as a lawyer. I worked in one of the nation's largest law firms as a litigation attorney. I've been to court in numerous states, in front of many agencies, various levels of courts, federal courts, state courts, and I have a lot of experience which I think is really helpful to be the district judge. Even though district court is smaller level disputes, they're still legal disputes, and that's why they're in court. And people that come to court deserve to have a court and a judge that is legally skilled and knowledgeable and in the best position to adjudicate the cases. So with my long record of service in my community, I know the people in my community, they know me, my legal and professional background, I think that I'm well suited to do the job. I think I've done a really good job for 6 years. I've worked very, very hard at it. It's an important job, and I hope that I've earned another term from the residents that I serve.
Okay. You have an opposition this time around, which is something, at least in our experience, pretty rare. Usually a magistrate is not often challenged in a re-election campaign. Can you maybe get a little bit into contrasting yourself and Mr. Ballo, who is your opponent?
Yes. But let me say first, I relish and enjoy the challenge. I ran for mayor 5 times in Kingston, and I always had a challenger. When I ran for magistrate in 2017 for the first time, I had a very well qualified and vigorous challenger then, and I enjoy the campaigning. I like seeing the people, meeting the voters again, and so I enjoy the challenge. I think the principal differences between myself and my opponent, let me list a couple of them. The first one is my opponent, who is not an attorney, is not certified to hold the office at this point and has not attended the required school in Harrisburg. Now, he can remedy that prior to taking office if he were to win. But at this point, he's not certified and not qualified. And I would contrast that again with my 30+ years of legal experience, my legal education from one of the best law schools in the country. And it's not all about academics, but it is a legal position, and clearly my legal background is useful and helpful to the litigants that come to court before me. Let me give you an example. I ran the numbers on April 25th. My office has handled 961 landlord-tenant cases during my first term, so we'll exceed 1,000 landlord-tenant cases by the end of the year. We've handled 1,437 civil small claims lawsuits at this point, so that will exceed 1,500, well over 1,500 by the end of the year. So that's 2,500 cases, landlord-tenant cases, small claims cases, 5,000 litigants that will come before me in the 6 years on civil cases. Every case, of course, extremely important to them. It might be the only time they ever come to court, to come to see us in magistrate court. And these folks deserve a judge that is skilled in the law, that is trained and experienced in the law. And I think that's the first major difference between myself and my opponent. My opponent also, he moved to our community of Kingston 3 or 4 years ago. I'm not certain when it was, but it's something like that. But I've been serving Kingston and the surrounding communities for over 25 years at this point. And I have a deep knowledge of the communities and the people and the issues. Again, I was the mayor of Kingston for 20 years. I know all the ins and outs of Kingston. I've been helping Edwardsville whenever I could. Particularly the most interesting time was when I took on the pro bono case of the Edwardsville Pierogi Festival and the Great Pierogi War case, which was international news, not just national news, but representing the Edwardsville Hometown Committee on a pro bono basis when they were threatened with legal action by a large chamber of commerce who said, pay us royalties or stop having your Pierogi Festival. And I volunteered and stepped up, and we were able to save the Pierogi Festival. Just recently, we saved the magistrate office, which the county was determined to move that to the 44th Airport, which would have been a tremendous inconvenience for the citizens of Kingston and Edwardsville, a disaster for disabled people that needed to have access to our court. And we were able to fight the county about that, give them some good ideas, and the court's going to stay in Edwardsville. So, I've been serving this community for decades. My opponent is a recent has recently moved in to our community. I think that those are the two biggest distinctions.
To follow up, you talked about your law practice, which is ongoing.
Yes.
Does that present any kind of conflict, whereas you might be handling cases and also hearing cases? I mean, do you see it? It
does not, because there's a strict code of ethics for magisterial district judges. That's for all judges at all levels. And so the magisterial district judge ethics code gives lawyer magistrates certain prohibitions. We cannot handle criminal cases in our county. We cannot appear in court before other magistrates and anywhere in the state. We cannot appear before local agencies, so I can't go to the Wilkes-Barre Zoning Board or the Edwardsville Planning Commission or something like that. So I scrupulously abide by all the ethics rules. It's really important. And so we don't run into conflicts. But there are times the magistrate conflict problem is that you know people, right? You're running for office in your community. You have supporters, you have detractors, you have people that financially support your campaign and whatnot. And so you have to be very scrupulous about saying, is there an appearance of impropriety? And if there is, you got to bail out. You got to recuse yourself. And so when I've recused myself in a number of cases over the years, not because I thought I couldn't be fair and impartial, but because I thought there might be a reasonable perception that others would think my partiality could reasonably be questioned. So it's something you've got to stay up on. If you were in my office, the ethics rules, they're dog-eared and with post-it notes in there, because we're constantly referring to the ethics rules to make sure that we scrupulously follow.
I asked the last candidate for magistrate in here about what their philosophy on bail is.
Right.
I kind of want to get your general philosophy on bail, particularly with everything going on in the country. Some other municipalities and bigger cities like letting people out without any bail. And to piggyback on that issue, I know that sometimes the prosecutors have been not agreeing with your position on homicide cases, where you think when they say that it should not be a bailable offense,
Yes. Thank you for the question. And with regard to the homicide, I've been proven correct on that, and I'll explain that to you in a moment. At our level, at the district court level, the lowest level on the judicial food chain, I don't think that we're entitled to have philosophies about anything. Our job is to apply what the law is. So when it comes to bail, the bail is in the federal and state constitutions. And then the rules of criminal procedure, starting at Rule 520, have a number of rules about bail, including a rule which sets forth 10 criteria that a judge must consider in setting bail. And that's not an all-inclusive. There's 10 you have to consider, and you can consider other criteria. So I wouldn't say I have a philosophy on bail. I follow the law on bail the best that I can. And so when I have an arraignment or a bail hearing, I take a lot of time with those, to the point that the central court staff gets mad at me because I clog the schedule up in central court, spending time doing bail hearings, going through the criteria that the law requires to make a decision. And I fashion those decisions the best way I can, given the rules that we have at hand. I would say this: in all the times that I have set bail, in 5.5 years, not a single time, to my knowledge, has the district attorney's office ever gone to common police court to raise my bail, to say that my bail was insufficiently low. I'm not aware of a single time that that's happened. I know there are times when defense lawyers have gone to common police court to modify the bail and said that I've set the bail too high, and that's happened. So bail's about following the law. The difficulty with bail is, you know, the media covers the bail, right? And so citizens that maybe don't understand the purpose of bail, which is to ensure the appearance of the defendants, ensure the safety of the community, and the compliance by the defendants with the conditions of their bail. The temptation is to make a name for yourself and throw big numbers at defendants. That's wrong. It's constitutionally wrong, and it's legally wrong. All right? So I make sure that I give as much consideration to defendants and to the arguments of the prosecution in the Commonwealth. I always give them a fair opportunity to make their position known as well. With regard to the homicide issue, this is a little inside baseball.
It is.
So I don't want to bore the folks that are watching this on the internet, but our magistrates are prohibited from granting bail to people that are charged with murder under section 2502 of the Crimes Code and manslaughter under 2503 of the Crimes Code. So if a case comes in with that charge, the magistrate has to say, as a matter of law, I cannot grant bail to this defendant. Go to common police court and seek bail. Luzerne County prosecutors don't charge generally 2502 or 2503. They charge 2501 of the Crimes Code, which is open homicide. And that says a homicide, it could be the intentional killing or the malicious killing, down to the negligent killing. Negligent killing would be involuntary manslaughter, which is a misdemeanor crime. And the prosecution has said, and they took me to court on this, and they were incorrect in their analysis. They said, I had a case where the defendant was charged with 2501, and I said, is this defendant entitled to at least a bail hearing? Now, at the end of the day, I denied him bail because I found him to be a danger. All right? But I thought that because of the 2501 charge, the defendant was at least entitled to a bail hearing because we weren't precluded by law from giving bail as a magistrate, because that would be a 2502 homicide or 2503 manslaughter charge. But you get a case, it's 2501, open homicide, it could be negligent killing, it could be a misdemeanor, for which you're clearly bailable. So I inquired about that. The prosecutor that was in court that day thought that I was wrong, and the fact that I even inquired about that made me biased in favor of the defendant, which was, frankly, a silly argument. Here's how I know that I've come out on top of this. The State Supreme Court Rules Committee has proposed wholesale changes to the bail rules. It's about 75 or 80 pages. In those bail rules, when they address homicide cases, the Supreme Court Rules Committee says, and I should have brought it, I could show you, says that when a defendant is charged with open homicide, the Commonwealth has the burden of showing that it is a non-bailable offense, a capital offense or life in prison offense when charged with open homicide. So the Commonwealth, if you charge 2501, you have to make the Commonwealth a showing that's non-bailable 2501. You can't just say, oop, we wrote 2501 on the form. Judge, you can't get bail. So the Supreme Court Rules Committee has agreed with me. Sorry about the inside baseball thing, but it's going to come up again and again in Luzerne County. And it's important. The most important thing in being a judge, besides doing it ethically and with integrity, is getting the law right. We have to get the law right. We can't just do things because that's the way we always did it in Luzerne County. And that's what they told me when I said, geez, 2501, should you have to make a showing before I deny this person bail? And I was told by the attorney for the Commonwealth, no. And I said, what's the legal reason for that? And he said, that's just the way we do it. And that's not satisfactory when people's liberty is at stake.
You mentioned Central Court. And I know the county has kind of gone back and forth on Central Court a number of times. What's your perception of how that system works now?
I think that the process that the county has in place works. It gets defendants, attorneys, public defenders in most cases, which is key. There's at least a prosecutor in the building if the prosecutor is not necessarily in the courtroom. So it does get the parties together, which is a little difficult with 16 magistrate offices, far-flung. So I think the Central Court system works for moving cases. I think the downside of Central Court is that the judges don't necessarily, we don't see our own cases. So for example, on Central, we have 16 magistrates. We can't all be scheduled when we have our own cases. It just wouldn't work scheduling-wise. So I'm there on Tuesdays. The Kingston and Edwardsville cases are there on Wednesdays. All right, so I see the cases when they're filed in my office, but I don't see the preliminary hearings. And I wish that we were able to see our own preliminary hearings. I know that scheduling-wise, that may be impossible for the way the cases fall and where the cases come from. So that's my biggest complaint with Central Court. But as far as the way it's organized and the way it functions, I think that it's largely positive.
Prior to being judge, obviously you did a lot of defense work, right?
Well, I did. I was a general practice lawyer. So my criminal defense issues were, I don't think I ever did a felony criminal trial. Yeah, so I would do misdemeanor cases, simple assaults, DUI, I did a terroristic threats trial. I represented a fella, this might have been a felony trial, who was accused of stealing money from a soccer league, and falsely accused, shall I say, the jury found him not guilty. So I was not, I wasn't your murder lawyer, I wasn't your possession with intent to deliver narcotics lawyer. I was the general practice lawyer. If there was a criminal thing that was sort of beyond what I did, I would refer it to somebody else.
And were you ever an ADA or a prosecutor?
No.
Okay. No. And I guess just I asked that because I don't know if police officers in general were skeptical that you did some defense work prior to, but obviously recently the Fraternal Order of Police unanimously endorsed your opponent, who is a police officer and a head detective. And
a director of the police union, so they endorsed their union compadre.
I just want to get your reaction because their endorsement will hurt or help. You.
Thank you for the question. This is a good question. All right. I was the mayor of Kingston for 20 years. Kingston has a strong mayor because Kingston has a home rule charter, so it's not like other boroughs. After the '72 flood, the reconstruction effort required centralized leadership because the town was 98% underwater. So Kingston has a strong mayor who can walk into the office and fire the department heads. That's the kind of power of the Kingston mayor. And so for 20 years, I was in charge of the police department in Kingston. So other than the few folks that have been hired recently, I hired all those police officers in Kingston. That drug unit, that 2 officers who shall remain nameless for public purposes, that may be the best drug unit in the county, I set that up. They were on the street. I took those officers off the street and set them up. Gave our police department the skilled manpower they needed, the tools they needed, and dare I say the freedom they need to enforce the law. And when you're the mayor and you're in charge of the police, that's the job you do. When you're the judge, you do the judge job, and it's a different job, all right? So I would put my record of public safety up against anybody for the work that I did for 20 years to protect my community. And not only with regard to the police, but when I got in office, Kingston had 16 firemen, not one of whom was a paramedic. Now there's 31, that joint department that we set up with 44, now has 31 firefighters who I believe, except for 2 or 3, are all also paramedics. So my public safety record is unparalleled in this area, all right? Because also the challenge with the police department in any community is to find the funds to keep it going. Right? Kingston only has 13,000 people. And to keep a police department of 19 or 20 and not have a fire department that's over 30, I mean, this is a challenge that I addressed. And so doesn't surprise me that the union would endorse the fellow who's on their union board of directors. There are issues with my opponent that I don't know that the union body was told about. For example, as I was getting my papers together today, I have the article by Jim Halpin from 2021 when Mr. Ballow was a named defendant in a federal lawsuit brought by a former Coughlin teacher, where the county's insurance company paid $750,000 to settle the case on the allegations that Mr. Ballow sought to coerce false testimony from a purported victim and witnesses, and that he had filed court documents and concealed exculpatory evidence from judges. And the county settled that case for $750,000. My question is, did the FOP body know that? There's another pending federal suit alleging malicious prosecution and various other misdeeds by my opponent that's pending. Did the union body know that? I suspect they did.
We recently wrote a story on the juvenile justice system, kind of concentrating on the DA's take that perhaps the system has gotten too lenient when it comes to juvenile offenders, and that it also, there's a lack of capacity for detention. How much of your job as a magisterial district judge involves juveniles, and what's your take on how the system is now, obviously after the Kids for Cash spurred reforms?
Excellent point. My court has a lot of juvenile cases for this reason. The Juan Valley West Middle School is in Kingston, so I get all the cases from the middle school. So we get 2 types of cases. We get truancy cases. We have dozens upon dozens of truancy cases. Many truancy cases are heartbreaking cases. Kids miss school, you find out that their parents have passed away from overdoses, or worse, the parent brings the child to the hearing and the parent is clearly under the influence of a narcotic. So we try to partner with agencies, social service agencies, to try to help these families, get these kids to school. So that's a big part of what we do, is trying to get kids to school and get them the help they need, get the families the help they need to address the underlying problems. So we're dealing with agencies and advocates to try to do that. With regard to the criminal element, I have a middle school, so the kids are between the ages of 11 and 14 by and large. There's really not much that a district judge can do to an 11 to 14-year-old. We certainly can't incarcerate them. We really can't fine them. The Pennsylvania Supreme Court has said that before you issue a discretionary fine, you have to determine the defendant's ability to pay. Well, children of that age can't even work, right? So you can't fine the parents for the criminal acts of the children. That's not legally possible. Community service is difficult because agencies don't necessarily want 12-year-olds to be supervising 12-year-olds for community service. So there is a hole in the system that needs to be filled. So I can't speak to the older kids in the high schools, but I know that with regard to the middle schools, the children that are charged with fighting and threatening behavior and disruptive behavior, the district courts, the legislature hasn't given the district courts a lot of power to deal with those kids. So that leads to them having to go to juvenile probation at the county where they have more tools and they can impose curfews and various things that we can't do. But the question is, what's the capacity of the juvenile probation system to handle these children? Because there are large numbers of, I'm having court on May 26th this year to clean up sort of the last couple months of the middle school incidents, and I believe there are 30 or more cases. I just have a whole day. It's a Friday, a whole entire day. I did it because I think it's a half a day for school, so we went with the kids in the middle school to come to court. And I asked the police a lot. I said, what would you like me to do? I talked to the district attorney's office and their juvenile prosecutor. What would you like us to do? I talked to the youth aid panel folks. What would you like us to do? Oh, so you can send the kids to the youth aid panel, but if the child doesn't want to go to the youth aid panel, you can't make it, right? They say no. So there is a hole in the juvenile system at the level that I am with the children of the ages that I see. I wish I was wise enough to have an answer to what should be done. And I don't know what should be done. Maybe the pendulum swung too far after Kids for Cash. But they're definitely, the middle school, I went to that middle school, that Valley West Middle School, and that middle school needs to be safe for the vast majority of kids that are there to learn and the families that want to send their children to a safe environment. So something needs to be done. I know there's been state representatives are involved and there's a panel going on. There's a meeting that I'll be at the middle school on May 18th to try to deal with this. So I wish there was an answer to it. But I agree that solutions need to be invented for this. I just don't know what they are.
Pretty good.
Last question? I think we might be out of questions.
Might be out of questions.
Unless you have something else.
Yeah, I want to say something. One or two things. There was the media story about the dog. What's the big deal? It's just a dog, right? It's not just a dog. All right. The dog is county property just as much as you take a county car home from work. The dog's county property. To use government property, I ran the government for 20 years. Right? To use the government's property for personal purposes is clearly improper. You shouldn't need a written rule for that. But the county has written rules for that. The county has an accountability, conduct, and ethics code. I might even have the section of it. Section 103.05M of the county ethics codes prohibits county employees from using county resources for any purpose other than a county purpose. So it couldn't be clearer. Let me back up and say, the first ethics rule for judges, when you read the Magisterial ethics rule, a judge shall follow the law. That's the first one. My opponent has a county property, a canine, which belongs to the county, that he uses in a political campaign. All right. To me, that's a fairly clear violation of the county ethics code. I know he said he loves the dog. I'm sure that he does. He has 2 other dogs in his house. If he wanted to use a dog, but he wants to use the county dog. And there was an article in the newspaper about that this week, and county officials said, so what? So what? That's the problem. That shows, I think, some of the problem with Luzerne County. So what? We don't like this rule. We're not going to follow this rule. A person on the Ethics Commission was quoted in that article as saying, I don't see it's a problem. When that person should have said, I'm on the Ethics Commission. I shouldn't be opining about what an ethics violation is when asked by a reporter. I should say that might come in front of me. All right? And so I think that you're running for a judicial office. You need to be, I've used the word scrupulous before. You need to be scrupulous about following the rules, about your personal integrity. All right? And the integrity that you apply when handling matters. Maybe I don't know what the rule is, because I don't look, maybe my opponent doesn't read the rules. He's a county employee, you'd hope that he would. Maybe he doesn't read the rules, maybe he doesn't care what the rules are, maybe he thinks there's loopholes. We talked about the appearance of impropriety, right? Which when you're a judicial officer is critical, because everybody's looking at you, right? And so, who's got the temperament, dare I say, maturity, judgment, to be the judge for 20,000 people?